third parties, or more frequently in recent times, trained and certified mediators. One matter which is controversial is whether or not arbitrators should, at the request of the parties, also perform any mediatory or conciliatory services. Most institutional arbitration rules do provide for such a possibility. The concern is that parties will find themselves trying to present cases in front of arbitrators who, while serving as conciliators, have already heard some of the viewpoints on the matters in issue and may have already tried to persuade the parties to accept certain outcomes. This possible conflict between the two roles often deters people from pursuing such a dual process. Nonetheless, the possibility of doing so remains open to parties should that be of interest to them. I can give you a dramatic example of the effectiveness of mediation based on a large, complicated case from my own jurisdiction. The dispute arose from a fire at an oil tar sands plant that was, among other reasons, alleged to have been caused by faulty construction materials in the plant. There were very large damages claimed as a result of the plant shutdown and the cost of replacing the structure damaged by fire. Over time, dozens of parties were named as defendants, ranging from designers, suppliers of material, contractors, and other related entities. All reasonable estimates indicated that this litigation would take at least 5 years to get to trial, and the corresponding expenditure on legal fees and expert witness costs and other forms of trial preparation costs would entail many millions of dollars. At the initiative of a committee of representatives of the defendant parties, a mediation approach was designed. The key to it was that the ongoing litigation was not hindered or delayed in any way, and the mediation of the dispute and the continuation of the lawsuit in its normal course occurred on basically two separate tracks. In other words, the mediation was exploratory and was left to a separate committee to develop. Lengthy efforts were made to interview and select the appropriate mediator, and in the end, an experienced mediator from British Columbia was selected. After his appointment as mediator, he began a form of shuttle diplomacy between the parties. The exercise eventually culminated in a successful settlement in less than 9 months after his appointment, likely saving the parties millions of dollars in legal fees. In the recent past, there has been a proliferation of training programs to encourage lawyers, in particular, to expand their skills and develop their ability to facilitate such services. Many prominent educational institutions in the United States and Canada in particular now offer training programs in mediation. Several significant business communities have set up mediation centers with a view to facilitating this sort of resolution. All indications are that the business community seems prepared to respond to these kinds of services. Now let me ask you this. What are some of the problems to watch for in this subject? Turning back to the arbitration process, if parties decide to draft their own rules of procedure on an ad hoc basis, or if they are attempting to agree on which of the institutions and their rules are most applicable to their relationship, it may be helpful for me to suggest a short checklist of items which is not exhaustive, but which you would want to consider. If you are negotiating or advising on international commercial agreements, please ask yourselves, first, and perhaps most fundamentally, will the national courts of the contracting parties be a satisfactory forum for settlement of potential disputes? In other words, is arbitration appropriate in the first instance? If you ask me that question, the answer will often be yes. But remember, arbitration exists within the larger picture of the world's judicial systems, and you should therefore always consider the courts as a potential option. If arbitration is an attractive option, it is then important to address a number of questions. Are all relevant parties or entities contractually bound to arbitrate? Arbitration by its nature can only occur by consent. Only parties who are signatories to the contract are bound to arbitrate. Should the parties rely on a recognized institution or forge their own way? Given the amount involved, is an institution cost-effective? Which laws should govern the contract? Where should the arbitration take place? What is the proper language of the contract, and what language should any arbitral proceedings take place in? Enforceability of an award under mechanisms such as the New York Convention require that arbitration be final and binding. So if you plan on using creative mechanisms, make sure you cover this basic rule of enforceability. With respect to the actual arbitration process itself, you should ask, how is the arbitration initiated? Who may be appointed as an arbitrator, specifically from what list of arbitrators, which country, which profession? In addition, how many will be appointed? Do you want a sole arbitrator or a panel of 3 or more? Also important to some of us, how will these people be paid? If the parties fail to agree on an arbitrator, what is the method for appointment? What do you do if one of the parties fails or refuses to participate in any of the steps along the way? What process do you want to use for defining issues and other pre-hearing matters? What time frames for completion are appropriate? What pre-hearing discovery of evidence by the parties will be required, and whether it will be documentary or oral? What forms of proof and other rules of evidence will be required? What provisions for interlocutory or pre-hearing relief are appropriate? Will the arbitrator's award be written or oral, with reasons or without? Can the arbitrator award costs or interest? Where do settlement procedures, including mediation, fit in the process? And finally, what level of confidentiality of the proceedings and the final award is required? As I said, these lists are not exhaustive. Rather, they are a starting point to ensure you are thinking about some of the important issues. And now let me ask you, in summary, what are the principal advantages and disadvantages of arbitration in international commercial disputes? While each dispute will be unique, let me list for you a number of potential advantages of arbitration. Impartiality of the decision maker. This is always an important consideration between nationals of different countries. Specific expertise of the decision maker, both in process and subject matter. Parties control the process, creating greater flexibility in terms of process and type of outcome. The proceedings are private and potentially confidential. The process is usually faster and maybe more economical. Limited rights of appeal should make the decision final and bring faster closure to the dispute, and arbitral decisions are enforceable decisions. Now let me list some potential disadvantages of arbitration. It applies only to parties to the contract in question. There is limited regulation and training of arbitrators. There are potentially limited remedies in the case of such relief as interest or specific performance. There are minimal summary procedures available, and sometimes potentially limited jurisdiction in terms of local law. Arbitration is not always less expensive or even more timely than court processes. International trade and commerce has been undergoing increasing liberalization in recent years. As the existence of the North American Free Trade Agreement shows, even significant sovereign countries such as the United States have been willing to negotiate bilateral treaties with their neighbors, and potentially with others further afield, to reduce barriers to trade and presumably to allow the unregulated market in goods and services to function. These developments are not always, of course, met with complete acceptance. No doubt, regional concerns and local needs will continue to play their part in containing this process of liberalization of trade. However, it seems reasonably apparent as well to all of us that national borders can no longer effectively be closed to international competition, and the relatively free movement of goods and services around the globe. Consequently, it seems likely that there will be an increasing need for the appropriate infrastructure to help the parties who trade in goods and services to deal with their activities, and in particular, the possibility that they may have disputes from time to time. Fundamentally, international commercial arbitration has many of the attributes which are necessary to permit private international law to serve commerce in a fair, impartial, and effective way. As I hope these brief remarks have reminded you, arbitration is not a panacea and will not necessarily serve in all cases. There are clearly limitations which parties can only try to anticipate in their private agreements. Nevertheless, when disputes do arise, I think it is fair to say international commercial arbitration has become well developed as a reliable means for resolving such differences. This fundamental fact will, I believe, continue to grow in importance. In conclusion, I should say I have attempted to keep my remarks somewhat simplified. I realize that for very knowledgeable professionals, I may have spoken too simply. This topic obviously deserves further inquiry and pursuit by those whose careers and livelihood may be affected. Once again, my thanks for your kind attention. I look forward to your comments and your questions.
Let us begin now with our first question and answer session. We will try to answer as many questions as possible. Therefore, we ask that only one question be asked per phone call, and that these questions be as brief as possible. You may call the studio directly at the phone numbers or fax which now appear on your screen. We remind you to make your phone calls at a distance from the monitor to avoid feedback. Our first question is coming in from la Asociación Interamericana de Mediación en Buenos Aires, Argentina.
Hola.
Hable, por favor.
Habla el doctor Ponieman.
This is Dr. Ponieman.
Les agradezco y
Thank you very much
en primer lugar darnos la oportunidad
for giving us the opportunity to share with you
con ustedes este seminario.
this wonderful seminar.
Y les agradecería si me pueden contestar.
I have a question here for you, which I will very much appreciate to hear your answer or your comments. In addition to the Supreme Court of Texas and Colorado,
En otros estados de
do you have in other states of the United States
se requiere al abogado
do you require the attorney to advise his or her client that they do have the option of resorting to ADR to resolve conflicts,
ya sea mediación
whether
arbitraje,
through mediation or arbitration,
en lugar de iniciar
instead of initiating or filing a suit?
y qué efecto tiene
And
esto con respecto
in which case, what is the effect with regard to the malpractice, with a malpractice case in the practice in the legal field?
Let me direct that question to Mr. Slate.
Yes, the states of Georgia and Colorado, and I'm advised most recently Alaska, have now directed through their rules apparatus for the practice of law that attorneys should advise their clients of an ADR option. It is clear in each of those instances, however, that the advice is hortatory in the sense that it's not required. With respect to whether or not failure to do so would have implications for malpractice, I think that's still an open question. But I do believe that this foretells a trend. More states are going to encourage attorneys in the practice of law, if not require them, to advise clients about mediation and arbitration.
Okay, we now have a live question coming in from la Federación Nacional de Comerciantes de Medellín, Colombia.
Gracias, muy amables.
Thank you very much for...
Okay. Muchas gracias por permitirnos participar.
Thank you for allowing us to participate.
Queremos hacer una pregunta. ¿Cuál es el nivel de aceptación
What is the level of acceptance
que hay de parte de las personas,
from
ya sean a tanto naturales como
the
jurídicas,
part of natural or juridic, legal entities
frente a los mecanismos alternativos de resolución de conflictos?
regarding the ADR mechanisms for
Mr.
conflict
Haigh,
resolution,
do you have an answer for that
Como
question?
el arbitraje y la mediación.
such as arbitration and mediation?
Y además,
And
¿qué
also,
desarrollo
what
legislativo han alcanzado?
legislation have you achieved?
O si por el contrario,
Or is it, on the contrary,
estas instituciones
that these institutions
se han formado
have been created, have been formed,
y desarrollado
and developed
sin tener
without any
una referencia normativa?
without any structure, rules and procedure structures?
Esta es nuestra pregunta.
That is our question.
Let me direct the first part of the question regarding the individual and judicial entities to Mr. Haigh.
Well, if I understand the question, Dick, my impression is that more and more companies and businesses are becoming interested in ADR. I think any time a business decision maker is involved in a dispute, they're very reluctant to give up control over how the process can work. And that's the real attraction of ADR, is that the parties involved themselves can begin to design the process by which they can get to a resolution. The second part of the question, I think, was to do with legislation. And if that's also directed at me, I would say in Canada we have, because we're a federation, we've passed legislation at both the federal and provincial levels setting up what are called commercial international arbitration acts. These acts basically recognize the New York Convention as a means of enforcing arbitral awards, and they set up the UNCITRAL model arbitration law as the means by which the parties can govern their dispute if they haven't otherwise contracted for the terms and provisions of how to deal with their disputes.
May I add quickly, in the U.S., three instances contributing to growth come immediately to mind. One, law schools are pervasively educating attorneys today about ADR methods. So attorneys coming into the practice of law no longer think only about litigation. Secondly, corporate general counsel, who are very bottom line oriented with regard to how much it costs a company to do business, are great advocates for the use of mediation and arbitration. So they are leaders in the movement. And thirdly, in the States, governments, including the national government, and I believe this was alluded to on an earlier broadcast by you, Dick, the current administration in Washington has signed a pledge to bind the national government in mediation and arbitration. And so the sum total of these are contributing to the very rapid and mercurial growth that we see.
Thank you. Our next question is again live. It is coming in from the Municipalidad de Huinca, Venanco, en la provincia de Córdoba, en Argentina.
Sí, buenos días, San Diego.
Good morning, San Diego.
¿Cómo fue la reacción
What was the reaction
frente a la Asociación Americana de Arbitraje
vis-a-vis the American Arbitration Association on the part of the judges? What was the judges' reaction? And was it in a few
ellos
cases
mismos
that they
derivan
themselves
casos al arbitraje
deviate or
y o a la
divert
mediación?
cases toward mediation and arbitration? Thank you. Do judges themselves divert things to arbitration and mediation?
Mr. Slate, would you like to address that?
Yes, indeed.
Senior
The
Slate.
answer is very much so, and increasingly. There's an interesting historical footnote here. Years ago, American courts felt somewhat competitive with arbitration. But this has been a considerably long time ago. And in the ensuing years, courts, through their decisions, have supported the use and the finality of arbitration. And as both state and federal courts have become overwhelmed with civil and criminal cases, they increasingly either refer cases to outside provider organizations, such as the one I represent, or they have set up what are called court-annexed programs within the court structure itself, so that in many instances, parties in civil cases must attempt mediation or arbitration before they ever get to see a judge. And so it's fair to say that the judiciary in the United States, both state and federal, are very engaged and very supportive of the process.
Let me just add something to that, Dick, if I could, that I think, and I agree with Bill's comments because I think they apply even beyond the United States. It seems to me that the success of arbitration and other alternative dispute resolution mechanisms depends to a large degree on the willingness of the judiciary to be restrained about not trying to compete against those kinds of forums to resolve disputes. Years ago, as Bill mentioned, there was a tendency for the courts to try to hold on to that domain. And now, in recent times, I think that we're seeing that the judges are prepared to, in fact, be supportive and refer matters to these alternative dispute resolution sources. And that's a key development all throughout the commercial world.
Thank you very much. Our next question is from la Comisión Federal de Electricidad, SECAP, en el Distrito Federal de México.
Gracias, buenos días.
Good morning. Helms-Burton law that has been passed by the United States of America is actually violating our NAFTA agreement. Therefore, we really need an international arbitration. Which of the two methods do you think the U.S. would choose, and which one do you think Mexico and Canada should choose, and why?
Mr. Haigh, do you have a comment on that?
Well, I agree with the comment. I say that with all respect for my hosts here today, but I think Canada and Mexico are quite aligned on this issue, and I personally do agree that it offends the NAFTA provisions. I suspect that this is going to be worked out, however, as a matter of working out the relationship on a political level rather than legally. That's my expectation. We'll see how that sorts out.
Mr. Slate, would you agree with that?
I agree entirely. I think it is currently more of a political, governmental issue than one, certainly, which has any implications at all for private commercial arbitration or mediation.
Okay, our next question is coming in from Panama. La Universidad Tecnológica de Panamá, en la ciudad de Panamá.
Sí, muy buenos días.
Good morning.
La pregunta es,
My question is, what is the main difference between the arbitration means, the system of the AAA and the one of the International Chamber of Commerce of Paris? What would be the difference in methods?
Mr. Slate, would you like to address that?
Yes. I would say, first of all, that the differences are not substantial. And again, underscore my answer by saying, to the degree there are differences, that this once again gives the parties the election to choose the process which is most suitable in their view to their needs. Two differences which I would point up and certainly defer to my colleague David for others include the fact that the ICC has a process which many consider very valuable on the front end of the arbitration, which is described as terms of reference, which sets down in a very detailed, planned way how this proceeding will go. By contrast, at the AAA, we have what's called an administrative hearing, which is, I think, fair to say, much more informal and achieves a similar result, but perhaps not in as great a detail. At the other end of the process, once a decision is reached by an arbitrator or an arbitral panel of arbitrators, it is the process of the ICC to refer that opinion to the entire ICC court for its review. Again, by contrast, at the American Arbitration Association, the decision of our panel is the decision in this matter. I don't believe, in my personal view, that these truly go to substantive considerations, but they do go to what the parties want and what their expectation is of the process. But I clearly defer to David for either correction or additions.
No, I think those are good comments. And in fact, in many ways, historically, the ICC represented more of the continental or civil law traditions. That's why the terms of reference were there, rather than depending on pleadings, which is the common law approach to defining issues. I think there was a feeling that the parties were to be called upon by the arbitrator or the person instead of a judge who would define the issue at the front end of the case. And there was a certain rigidity about that, which common law tradition didn't really go along with. And I agree. I think the AAA rules are far more flexible and streamlined these days, although ICC, as you know, is undergoing a pretty significant rule revision these days. In terms of how they actually do it, substantively, I've done both kinds of arbitrations, and I must say I don't think that there's a lot of difference. It really depends on the parties themselves, how they work it out.
Thank you very much. Our next question is from La Universidad Privada Boliviana de Cochabamba, Bolivia.
Gracias. Bolivia
is currently creating a draft for a conciliation, mediation, and arbitration law. In your opinion, do you think that there are very important differences between conciliation and mediation that would merit a different chapter, or do you think that they should be considered as one and the same thing?
Mr. Haigh, what do you say?
Thank you.
Well, I personally worry that the difference between conciliation and mediation is really semantic rather than practical. I think of them as being part and parcel of the same kind of process, where you have a neutral listener, in one instance probably more activist than in the other, but generally I wouldn't think different rules need apply. That would be my quick response.
And I agree entirely. Recently, when we were drafting the rules for the entity called CAMCA, the Commercial Arbitration and Mediation Center for the Americas, for private disputes under NAFTA, which I will talk about in my presentation, we considered this issue. And it was our considered judgment that we agreed 100% with David Haigh, and that a set of mediation rules would cover all of the areas which are typically discussed under either the banner of conciliation or mediation.
Thank you very much. Our next question is coming from KTV Comunicações in Rio de Janeiro, Brazil.
Sim, KTV. Por favor, Pedro. Just a moment, please.
Hello, my name is Pedro Martins from Rio de Janeiro. I'd like to address a question to both conferences. Is if in the arbitral proceedings carried out in Canada and in AAA, a party shall always be represented by a legal counsel, or if the presence of a lawyer is not necessary. I mean, if the representation of a lawyer is a matter of sole discretion of a party. Thank you.
Mr. Haigh, would you like to address that?
Sure. It's a good question because it does come up from time to time in various kinds of specialized arbitrations that it really isn't even appropriate to have a lawyer. For example, short-term arbitrations over agricultural products disputes are often dealt with specifically by people who are expert in that particular matter, and it's not necessary to have advocates. On the other hand, it's traditional or customary in common law jurisdictions particularly that parties are represented by counsel. So as a matter of practical application, it's almost invariable that in commercial disputes parties are going to be represented by counsel, but they're not obliged to do that. It's not a requirement.
Okay, we have one more question now. We're going to have to be quick with this. It is coming from Saño de Norteamérica en Tijuana, Baja California, México.
La instancia definitiva que en el caso de la no aceptación del laudo por alguna de las partes, ¿y cómo podría esto afectar el concepto de soberanía nacional?
Would this affect the concept of national sovereignty? The first part of the question was cut. I couldn't hear. I hope that it's enough.
The question is, if one of the parties rejects or does not accept the arbitral award, does that have a problem in terms of national sovereignty when the parties are from different countries? Mr. Haigh?
No, the really amazing development in the last 30 years or 40 years in international private disputes is that parties no longer can hide behind sovereign immunity to avoid the enforcement of awards. That's the short answer. The convention, the New York Convention, the Inter-American Convention, and others all allow the party who has the judgment to go directly to the home state of the contracting party and enforce their award. And the possibility of sovereign immunity just doesn't arise for private disputes. It does for governments, where government agencies are involved, unless they have especially entered into contracts that call for, say, resolution in front of institutions like the World Bank, the International Center for the Settlement of Investment Disputes. Then governments themselves can still claim sovereign immunity, but not private parties.
Gentlemen, thank you very much. Let us continue with Module 2, in which Mr. Slate, whose presentation was pre-taped in Washington, D.C., will explain the role of the American Arbitration Association, or AAA, in supporting today's international ADR activities.
It gives me enormous pleasure to join my colleagues Dick Page and David Haigh, two of the leading experts in the field, to discuss with you the exciting evolution of dispute resolution in the international arena. International commercial dispute resolution is expanding in many ways and in many directions throughout the business and legal communities, and has even found its place in business and law schools, both here and abroad. Recently, I was fortunate to serve as a judge in the final round of the Willem C. Wies International Commercial Arbitration Moot, held in Vienna, Austria in March of this year. The competition, which brings together incredibly talented students from around the globe to find solutions for real-world conflicts in commercial business, represents the growing awareness of international ADR, which has permeated virtually every area of public and private life. The world is entering a most exciting stage in the development of dispute resolution as an alternative to the kind of litigation which often debilitates winners as much as losers. Every sign points to a growing appreciation and acceptance of the value of dispute resolution, not just as an alternative to litigation, but as a set of options to be built into legal and business planning. Well, what forces are driving the sea change in attitudes among lawyers toward the greater acceptance of alternative dispute resolution? Three factors, among many, come to mind. First, faced with staggering backlogs, courts are now formally urging attorneys to turn with increasing frequency to dispute resolution services for cases which do not, per se, require a judge. There is a growing body of opinion espousing ADR as a vital part of law and not a separate business practice. And the American Bar Association created the section on dispute resolution in the last few years, the first new section to be created within the ABA in 20 years. A growing number of law firms around the globe have recognized the value of dispute resolution as an integral part of the practice of law and have developed dedicated practice groups to advance a full range of dispute management and resolution services to their clients. It is now widely recognized that ADR techniques should be a part of every lawyer's toolkit. These techniques, applicable to an ever-widening range of industries and books of business, are incorporated into ADR programs by corporations, which seek, through clear vision and planning, to keep an eye on the bottom line. ADR cuts across a wide range of industries, and in industries